You're about to hear something that could change the entire landscape of gun ownership in America. A move so significant, so unprecedented, that it's sending shockwaves through every state, courthouse, and gun rights organization in the country. The Supreme Court and the Department of Justice have just taken coordinated action that could bring an end to firearm permits as we know them, and it's happening right now. For decades, Americans have been told that owning a firearm requires permission, a permit, an application, an approval from the state. But this new decision, paired with a direct action from the DOJ, could completely rewrite that system. The message from Washington is loud and clear. The right to bear arms is not a privilege, it's a constitutional guarantee. Let's break this down step by step. It all started when several states began enforcing strict firearm permit systems that many saw as unconstitutional. These laws often required law-abiding citizens to go through months of background checks, classes, and waiting periods just to exercise a right already guaranteed by the Second Amendment. Gun rights groups fought back, and after years of legal battles, one case finally reached the Supreme Court. And that's where everything changed. In a stunning move, the court voted in favor of the plaintiffs, issuing a ruling that could dismantle firearm permitting nationwide. The decision, supported by a majority of justices, declares that the requirement for citizens to obtain a permit before carrying or owning a firearm violates the fundamental intent of the Second Amendment. The court's majority opinion emphasizes that the right to bear arms shall not be infringed means exactly what it says: no extra permission, no state-issued pass, and no bureaucratic delay between a citizen and their constitutional right. But what makes this even more explosive is that the Department of Justice, yes, the DOJ has decided not to oppose this ruling. In fact, in a rare alignment, DOJ officials reportedly stated that they will support the court's decision by issuing updated federal guidance to all 50 states, advising them to review and eliminate firearm permit systems that contradict the ruling. In other words, this isn't just a court victory, it's a federal shift in policy, a complete reversal of how firearm regulation has been handled for decades. Gun rights advocates are calling it the most significant Second Amendment victory in a generation. Across the country, groups like the NRA and the Firearms Policy Coalition are celebrating what they describe as the restoration of constitutional balance. For years, they've argued that requiring a permit for self-defense is not just an inconvenience, it's an infringement. And now, the nation's highest court seems to agree. However, the reaction hasn't been unanimous. Several state governors, especially those in states with strict gun laws, have vowed to resist the implementation of this decision. California, New York, and Illinois are already exploring ways to modify their state laws to comply, while still maintaining some form of control over who can carry. But according to legal experts, their options are limited. The court's wording leaves little room for interpretation. Any requirement that delays or restricts a citizen's access to a firearm could be struck down. Meanwhile, the DOJ's position has effectively tied the hands of federal agencies that once enforced those restrictions. Under the new guidance, local law enforcement may soon find themselves unable to deny applications based on subjective criteria, such as good cause or moral character. The new standard: if you're a law-abiding American citizen, you have the right to carry, period. This decision has already begun to ripple through state legislatures. Reports are coming in from multiple states where lawmakers are rushing to repeal or rewrite their existing firearm permit laws to avoid federal lawsuits. Legal analysts predict that within months, we could see a nationwide recognition of permitless carry, something that once seemed impossible. But this raises an even bigger question. What happens next? Will states comply quietly, or will this trigger a new constitutional standoff between federal authority and state sovereignty. Behind the scenes, there are already talks of major political pushback. Some state attorneys general are preparing new challenges, claiming that the court's decision oversteps boundaries and undermines public safety. Yet supporters argue that public safety has never come from restricting the rights of the responsible, it comes from empowering them. And as more details emerge, it's becoming clear that the federal government might be preparing for a new era of national reciprocity, meaning your right to carry could soon extend across all 50 states, without needing any separate permit. To understand the magnitude of this change, we need to look at the legal precedent. This ruling builds directly on previous landmark decisions, like Bruin v. New York State Rifle and Pistol Association, where the court reaffirmed that self-defense outside the home is protected under the Constitution. But this new action takes it a step further, not just reaffirming the right, but stripping away the bureaucratic barriers that diluted it. It effectively says the right to carry doesn't need government validation. Gun control advocates are, unsurprisingly, outraged. Within hours of the announcement, social media platforms erupted with calls for emergency legislation and new safety protocols. But the reality is, this decision doesn't create chaos. It restores balance. It reminds both citizens and government officials that constitutional rights aren't optional and they don't require permission slips. Even within law enforcement, the reactions are mixed. Some sheriffs, especially in constitutional carry states, have praised the decision, calling it a long overdue recognition of American liberty. Others, particularly in urban areas, worry about the logistical impact of a sudden end to permit systems. But as the DOJ's new stance rolls out, many agencies are being instructed to prepare transitional procedures that respect the ruling. Now, let's talk about the bigger implications. If firearm permits are officially phased out nationwide, this could set a precedent for how the Supreme Court approaches other constitutional issues. We could see a domino effect one, where rights that have been slowly regulated by state authorities are restored to their original intent. It's not just about guns. It's about freedom, consistency, and the limits of government control. For millions of Americans, this moment feels like vindication. Years of fighting, lobbying, and court battles have finally led to a clear message from the highest court in the land. The Second Amendment means what it says. And that message is now being enforced, not just in theory, but in law. But make no mistake, this battle is far from over. Already, anti-gun organizations are mobilizing new campaigns to push Congress toward alternative measures, like enhanced registration databases and federal tracking programs. They may have lost this round, but the fight for control never truly stops. And that's why staying informed and vigilant is more important than ever. What we're witnessing right now is a shift, a seismic change in how the Constitution is interpreted in modern America. A shift that returns power back to the people, not the politicians. And while opponents will continue to fight, the foundation of this decision is solid. Because once a constitutional right is restored by the Supreme Court, reversing it becomes nearly impossible. So, what should gun owners expect next? Legal analysts predict a gradual rollout. States will begin removing permit requirements over the coming months, aligning with the DOJ's updated guidelines. Some will resist longer than others, but the legal precedent has been set, and it's only a matter of time before the entire nation moves toward permitless carry as the new standard. Gun stores and concealed carry trainers are already preparing for an influx of new buyers and carriers. And as this new era unfolds, it's clear that the balance of power has shifted back toward the citizens who believe in self-reliance and the right to defend themselves and their families. This is more than just a legal update. It's a moment of constitutional clarity, a reminder that rights are not granted by government officials. They're recognized by the Constitution itself. And when the highest court and the Department of Justice stand on the same side of that principle, it sends a message that echoes far beyond Washington. Whether you support this decision or not, there's no denying it marks one of the most consequential moments in modern American legal history, a moment that could define the Second Amendment for generations to come. And as this story continues to develop, one thing is certain: the age of permission-based rights is coming to an end. This is the beginning of a new chapter in the fight for freedom, and it's happening before our eyes. Stay alert, stay informed, and remember, the right to keep and bear arms shall not be infringed.